you go about preparing your clients for trial?
Sure. So it depends on what issue is being tried, but example being if it's a custody trial, one of the very first things that I do if I perceive that there's a possibility of custody being contested, we send out our clients what's called a custody questionnaire. We also send them a factor chart, and we also send them an event timeline. So I'll explain each of those. The custody questionnaire is a very, very lengthy document. It's going to try to provide me as much information and background on the parties as possible. It even has at the end a skeleton in the closet questionnaire so that I walk through, and I'm not surprised at trial when somebody comes up and says, oh, wait a second, what about that time that you were a stripper or a prostitute 10 years ago? Well, I'm going to know about that because they filled out the questionnaire. So they go over the questionnaire, then they send that back to us. We schedule an appointment to go over that questionnaire. Again, all that takes place relatively early on in my retention, well in advance of trial. The other thing that they're going to get is a custody factor chart. So that constitutes every conceivable factor that the court considers on a contested custody determination. So about 20, 30 different factors that are derived from the case law on child custody. And I have separate columns where they fill in all the facts and circumstances which both are positive and negative factors on their end, but then a separate column for positive and negative factors with regards to the other side. And so they go through every single factor because I want to know, are there any issues of mental illness or domestic violence, et cetera, et cetera. I put in an instruction provision at the beginning of that factor chart that says, look, if the boxes that I've provided, although it's in Word format, if they're too small, you can either expand the size of the box or attach a separate sheet or whatever and really expand on what you're putting in there, giving me as much detail as possible to flush out all those factors. Then I also give my clients an event timeline. I tell them, don't just start from now and go forward as the case is pending and fill in all those relevant events. Also go backwards in time, because I want to know what's been going on between you and the other parent over the last year or 2 or 3 years. And so I want you to fill in this particular thing happened on this date. Here's what happened from my perspective. Then I have a separate column on that event timeline saying, okay, here's what happened. Here's the evidence that I have to corroborate that. Here's either the witnesses that I have. Here's the emails or the text messages or the videos or the audios that back that up. So, and that goes to every single event. The purpose of all this is to make me better at trial as one's attorney. Because if I have all that together, it then makes it easy to form a script of your direct examination and the presentation of your direct case, because I'll have everything that happened in the order that it happened, as well as lining up every single piece of corroborating evidence, and I'll have that relatively soon in the beginning of the case. A lot of other attorneys I see, they'll only start preparing when they're for a trial, when there's trial dates set. In my humble opinion, that's a big mistake. You do not want to start preparing for a trial only when you have trial dates set, because there might be relevant information or documentation that you'll need that you need to send out subpoenas on. but you also want to know about those positive and negative factors as soon in the case as possible. The other thing that I would say is on the financial issues, I do similar factor charts. So I will send out my clients asset distribution charts, maintenance distribution charts. And again, in New York, maintenance is synonymous with alimony. I also have a child support variance chart that, again, lays out all the statutory factors and will allow them to tell me, okay, here are the relevant facts that are both positive and negative on my end. Here are all the relevant facts that are positive and negative for the opposing party, and then refer to any corroborating evidence on those issues, both on assets, maintenance, and child support distribution. So, again, proper case, of course, it's dependent on your individual client because I'm only the coach. I can tell you the play. I can't force you to run with the ball in the proper direction. So as the coach, I give my clients all these factor charts. I tell them to fill it out. But if my client then waits until closer to trial, that that's it's their life and it's their case. So I can't force them to prepare. But as best as I possibly can on my end, I start preparing for a trial as early in the process as possible. Now, certainly if the case settles in between times, well, then, the worst that happens is you've done overkill. But the best that happens is now you're well prepared for a possible trial.